Good afternoon, everyone, and welcome to today's Wellness Regulatory Update. I'm Jenna Westenberg with HealthCheck 360. We have a great presentation for you today, but before we get started, I'd like to take care of a few housekeeping items. We will have time for some questions at the end of the presentation. If you have any questions, please type them into the question box in the lower portion of the control panel. We'll also be posting a recording of this webinar online, so if you'd like to replay this at a later date, it will be available. Also, if anyone would like a copy of the presentation, please send an email to me or type your request in the question box. Today we have HealthCheck 360's Michael Kelly with us to talk about the impact of the latest regulations released by the EEOC on wellness. Now I'll turn the presentation over to Michael.
Great. Thanks so much, Jenna. We've had a lot of questions in the last couple weeks since May 16th when they've released their final versions. And essentially we wanted to regroup, even though we did one of these just a few weeks ago, and you know, it was highly attended, and the request was that that we do it again. And so, you know, what I'd like to do today is provide some background, you know, to the regulatory environment and wellness. And you know, we really appreciate you joining us for kind of a rather dry but always well-attended topic. And I have to issue my disclaimer. As always, you know, we will seek to answer every question you have. We provide regulatory guidance to all of our broker consultants and clients, but this is not intended as legal advice, and as always, you should work with your primary legal counsel on all matters obviously impacting the regulatory environment and your employee benefits plan. But at that being said, we spend a great deal of time with this and pride ourselves on giving the best possible interpretation, and that's really oftentimes what it is, because the marketplace moves faster than the regulatory environment, and frankly the marketplace was not struggling with the need for additional rules in this space. One of the things we'll see in the background is that healthcare reform really did a nice job of codifying what the rules that we were expected to play by in terms of wellness and health management programs. So we'll look at that background. We'll take a look at the recent events, which is why most of us are here today, and you know, and talk about how essentially the EEOC has passed a series of rules under the Americans with Disabilities Act and enforceable by the EEOC that actually at times conflict with the ERISA and healthcare reform rules that were in place. And so what we're going to do today in order to simplify that kind of inherent contradiction is we've laid out all of the requirements side by side so that you can see them, and essentially our advice is very simple. We believe that you have to adhere by the minimum standard that any of the three agencies are asking you to look towards. And then finally, we like to leave some time for some questions and answers, because I know there's a lot of them out there, and we want to address everything the best we can. So let's get rolling. In this first section, we're going to go pretty quick in terms of background. But the major players in this are numerous, but we can distill them down to three main buckets. And it's actually two. But Health and Human Services, Treasury, and the IRS all got together to pass the ERISA laws, HIPAA, and the Affordable Care Act, which is where we have seen our standard wellness regulations that we've all been abiding by really since 2007. And they got more codified, obviously, with the Healthcare Reform Act. The other party that has now decided to put their 2 cents in, and it's a significant 2 cents, is the Department of Labor, and more specifically their branch of the Equal Employment Opportunity Commission, which is charged with enforcing the Americans with Disabilities Act. But what's really kind of interesting is that the DOL and the EEOC also applies the Genetic Information Non-Discrimination Act, GINA, as a way to place wellness rules on spouses and family participation. But it's primarily only focused on the collection of genetic data, historical family medical experience, and very applicable to probably everyone on this call, the incentive guidelines for spouses in your wellness programs. And we will cover all of those things. So the timeline is fairly straightforward, but is important because you'll see that there's essentially two different timelines occurring. July 1 in 2007, HIPAA clarified the non-discrimination requirements and the wellness program rules. And this is where we first heard the terms participatory versus outcome, and kind of the five standards, five rules that we're all pretty familiar with that were codified more so in the Healthcare Reform Act, and those rules were then effective as of 1/1 for 2014. What was interesting, while these rules were all very clear and were passed by Congress, which is important, none of these were administrative, the EEOC was issuing a series of informal letters saying that they were not in agreement with these rules, and they kind of put a lot of threatening verbiage and commentary out there, except they were non-binding. So they were putting opinions out there that said that they thought the rules were wrong and that employers were potentially at risk, but they weren't doing anything in terms of actually stating their own rules. What was interesting is they still never stated their rules, but the EEOC filed 3 different lawsuits at the end of 2014. And we're going to discuss those suits very, very quickly. And the EEOC fared very poorly in them. And as a result, they realized that they needed to issue their own set of rules, and they stated that their intention was to be consistent with the ACA rules, but as you'll see today, they failed fairly miserably on that consistency. And so the biggest and most important recent event is as of May 16, 2016, the EEOC issued their final ADA and GINA rules, which are enforceable for the major changes for all health plans starting on 1/1 of 2017. And as I said, let's look into this kind of quickly. But the HIPAA and ACA background, all the way back in July 2007, they obviously HIPAA prohibits discrimination against individuals based on health status, but they made an exception for benign discrimination in favor of individuals with adverse health status, meaning a health plan could provide benefits to people who had an adverse health status. A simple example is the health plan can provide free diabetes supplies to those with diabetes. And they also made exceptions for HIPAA wellness rules. So if you were not participating in wellness programs, you could treat those employees differently than in those that were participating, or even those who were hitting certain outcomes. And the Affordable Care Act codified those rules, and the final wellness program rules were issued in at the end of 2012. The final rules were issued in the spring of 13, and they were effective for all plans renewing after 1/1/2014. And the intent of the regulators here is important. The challenge is that, which is a good thing, they wanted to make sure that all wellness programs were reasonably designed to promote good health, which is perfectly fine. And they didn't want companies to use wellness as a subterfuge to discriminate against unhealthy employees. And again, I think that is a worthwhile cause. So they went to really clarify the 5 requirements of health contingent wellness programs. But what healthcare reform actually did well, which is not a lot of things, the intent actually stated, the regulators stated that the regulations continue to permit plans and issuers flexibility in designing reasonable alternative standards so that companies and employers could continue to innovate and create new and effective incentive structures to drive employee health in a positive direction. So again, the only laws that have been passed by Congress, the intent was to continue the good work that the wellness industry and health management and the brokers were doing in this space, and to not stifle innovation. And the rules were fairly simple. You know, in typical government fashion, it took 116 pages of 6-point font to explain them, but they were all essentially fairly rational. You've got to give individuals the opportunity to qualify for a full reward at least once per year. And there was a lot of language around the full reward. The reward for all health contingent programs was maxed at 30% of the total cost of coverage. But a smoking cessation program or has a smoking cessation contingent, it could be as high as 50%. Again, with the theme, the program must be reasonably designed to promote health or prevent disease. It must be available to all similarly situated employees, and that's where the most language came out, is you had to do that by providing a reasonable alternative standard, and you had to communicate that it was available to everyone to get the full reward through providing a notice of the availability of reasonable alternative standard. This has largely been very effective for the last few years, and so, you know, most of us were pretty shocked when we saw that the EEOC under the ADA was taking a different track. And the history there is also kind of important, because you're going to see that their new rules are a departure from the legal cases and the courts involved with the ADA, the EEOC, and wellness. The ADA was passed by Congress in 1990, and you know, it was essentially the first comprehensive civil rights law addressing the needs of people with disabilities and prohibiting discrimination in employment, public services, public accommodations, telecommunications, etc. And the EEOC was given the enforcement authority for the Title I of this act. And the main thing to remember is that the ADA generally prohibits employers from requiring employees to take medical examinations, but they wrote in a very specific exception for bona fide benefit plans. And as you're going to see over these next couple early cases, this is one of the reasons why we believe that the EEOC kind of has had to pass their own set of rules to get what they want. But it's also a reason kind of separately that we think that you should wrap your health and wellness plan underneath the prerogative of the health plan. But then you can still make it available to all employees. And so there's occasionally a lot of ERISA questions saying, you know, do I have 5,500 requirements and other ERISA requirements for my wellness program? And the answer is possibly. But what we're advising our clients to do, and what the very clear best choice, best practice is that you want to roll out your employee benefit program as a component of your employee benefit plan, and especially the medical plan. And that way, the wellness program does not require other ERISA requirements like 5,500 reporting or requirements and all of the reporting associated with that. But it's also linked because of this bona fide benefit plan. The wellness program should be a contributing factor to the overall benefit structure and the medical plan, especially because of that bona fide exemption. And the first time this was tested was actually in Florida, in Broward County. And an employee brought this lawsuit. Important to note, an employee brought this lawsuit, not the EEOC. But the federal court ruled that Broward County, he did not focus on what the EEOC focuses all the rules on, and that is the question of voluntariness or mandatory. What the judge went straight to is whether the wellness program qualified for the ADA's bona fide benefit plan exemption. And he found that it did. And it was also upheld in a separate appeals court. So two federal districts found that their wellness program and providing incentives that were, again, reasonable and moderate, that all of this fell under the safe harbor of the case. So, you know, in this case, this is the first time we really saw significant incentive structures on a health plan linked to wellness challenged. And the district court here noted that the program was designed to help develop and administer the benefit program, the medical plan, and that they use it as a decision-making tool. But the district court also found that it was not a subterfuge and that the program is beneficial to the employees of Broward County, disabled and non-disabled alike. And you know, all of the rules that we kind of just went through on the ACA side really clarified and made sure that people weren't able to discriminate to the disabled because of the reasonable alternative process. But what's fascinating and what we're here today is talking about the separate history of the EEOC. Essentially, as I noted, and I'm not going to go into all of them, they issued a series of informal discussion letters. I have them linked here for you, and if you receive the slide, you can look at them directly. they focused almost exclusively on whether a wellness program was voluntary or not. And in the employee benefit realm and wellness industry, we define voluntary programs as programs that don't have an incentive structure, that are not mandatory, meaning that even if there's an incentive, an employee has a choice to not participate. The EEOC, and you're going to see this in the legislation, essentially started filing lawsuits on the basis that even though incentive structures met the codified law of the land from healthcare reform, they challenged that if an incentive was of a certain value or higher, that it was no longer voluntary. But again, remember that in this whole period of time, they did not clarify what that break point was or what the financial incentive levels that they felt was unfair that made things not voluntary. So they really dug up their own problems. And, you know, we're not going to spend a lot of time on these letters, but essentially after those, we heard nothing. The EEOC made no attempt to reconcile the established rules of healthcare reform in their own interpretation. And frankly, the letters were posted and intimidating enough that employers were actually asking for this information, as were industry groups, the wellness and health management industry, and brokers. But the important consideration is that the EEOC appeared to be playing by a separate set of rules with no forewarning to companies whatsoever on what those expectations were. And you know, those quotes really came from when the EEOC decided to act, and essentially they acted by suing 3 employer groups. 2 of them were in Wisconsin and the 3rd was in Minnesota, and it's interesting to note that all of the lawsuits came out of the EEOC's Chicago office. So even though they have now since finalized and codified essentially what their expectations and regulations are, prior to this, it's kind of unknown if a remote office just had a very strong opinion and decided to kind of go rogue and file suit against these employers, or if it was coming from the entire organization and senior leadership. The outcomes were not positive for the EEOC, and it's interesting, these outcomes still contradict what some of the regulations are and how some employers could potentially challenge their regulations because they essentially did not address the bona fide plan exemption. And so we'll look at these shortly. And you know, the last component or last thing to happen is that following the filing of these 3 suits, which is an interesting time frame, right? The organization decided to bring lawsuits, and then they proposed their own sets of rules and regulations to address the interaction between Title I of the ADA and the financial incentives as part of wellness programs, of which were common in the marketplace. And so we saw the proposed rules in April of 2015, and you know, the final rules after thousands and thousands of comments, they didn't change a lot of what they were proposing. So, you know, what we found was in the Honeywell case, the EEOC, this is the most important case to me because here the Honeywell wasn't really doing anything wrong whatsoever. The other cases, I think there were some mistakes made by the employers, but here the EEOC sought to restrain the wellness and benefit program because they thought that the penalties, although they were meeting the goal of the 30% of the ACA, they were abiding by all the laws that were established. The EEOC essentially just thought that it was unfair. And it's interesting because the district court denied the EEOC's request for injunctive relief, and the case was later voluntarily dismissed. And I provided a link at the bottom of the page where you can find out more information. But it's interesting that the EEOC, again, bringing lawsuits and failing horribly, decided to press onward with their own set of rules that contradict what we were playing by. The FLAMBEAU case judgment was even kind of a more specific loss to the EEOC. here the EEOC argued that the SEF decision and the bona fide benefit exemption did not apply. Once again, federal court rejected that argument. The EEOC tried to say that a different exemption under the ADA, that the voluntary health employee health program would be irrelevant by applying the ADA safe harbor to the company's wellness program, and the court disagreed. Again, I have the link for you if you want more information, that the ADA safe harbor was applicable here, and the company, the case was settled in favor of the company. And it's notable that even though the health plan at issue itself was fully insured, the court relied on it to apply the ADA safe harbor on a bona fide benefit plan. And in this case, the plan was self-insured by the employer. So, you know, we've had lots of case law where the EEOC is repeatedly losing because of the ADA's bona fide safe harbor. But we also still learned some things that the court decided in FLAMBEAU. And one of those is if you were going to make programs mandatory, you had to see that the wellness program requirement has to be a term of the employee's benefit plan. So again, lump your wellness into the summary plan description of the medical program. Again, you had to provide adequate notice of any wellness program requirement. And the wellness program requirement must be based on underwriting risks, classifying risk, or administrating such risk. Again, that goes back to the safe harbor requirements. And then here again, the wellness program must not be mandatory. And I think that's always been, at least at Health Check 360, we've always provided that advice to our clients. It's not a best practice in terms of communicating to the employees. And regulatory, we think that the word mandatory always causes issues. The EEOC, of course, addressed that and pretty much said that that is now the case definitively. So what they did after losing several court cases is on May 16th of this year, they issued their final rules under the ADA and GINA. And what's challenging is that although they said their intention was to be consistent with the Healthcare Reform Act, they are not entirely aligned with ACA regulations. And so I think what we're going to do for the remainder of our time, and we're going to go pretty quickly, is to note the differences between those rules and the ACA regulations. And then the time frame is important. The final rules have been released, but the incentive guidance and the communication requirements are all effective as of your plan's renewal date after January 1, 2017. So again, let's compare essentially the three buckets that we've referenced and has a history with now governing wellness programs and health management programs. So we have the HIPAA and Affordable Care Act, we have the ADA and the EEOC, and we have the ADA and GINA. And the following slides, I have to apologize, are kind of overly detailed and monotonous, but what we wanted to build here was a reference point for everyone that joined us to be able to look back and compare and say, okay, I have a question on eligibility or notice or incentive caps. And here you'll be able to compare what the three different laws say. So again, our advice as we look through these is that you take the lowest common denominator. If the laws conflict, meet the minimum requirement of the three, which I think is typically going to be the EEOC. I have, however, talked to some attorneys that because the EEOC in its regulations never addressed the bona fide benefit plan exemption, there's the potential for some companies to challenge these under that exemption. We don't expect that to see that because in order to challenge it, you know, you would have to do that through litigation. And frankly, we don't see a lot of companies wanting to burden that cost to challenge the EEOC rules. But we'll see. It'll be interesting to see if some companies do take that track. So covered employees or programs, who does this apply to? Essentially, this is a really important consideration. The HIPAA and ACA rules apply to all health contingent wellness programs. And so if the program is related to obtaining a standard or if the program requires some type of activity that could be discriminated or focused on health, meaning even if it's just a walking program and you have to do a certain number of steps, that's a health contingent wellness plan in our definition, because you would have to provide a reasonable alternative to somebody who is wheelchair bound or has another disability that would prevent them from attaining that goal. So it's not just about the incentive structure. Participatory wellness plans, according to the Healthcare Reform Act, really didn't have any set rules or caps on incentive structures. And so you're going to see a significant break in terms of who this is applicable, because the ADA, the EEOC, is saying that really any wellness program sponsored by employers with 15 or more employees that are going to be collecting information about an employee's health or medical examination, this applies to. So think of it this way. If you're doing any kind of health risk assessment, if you're doing any kind of biometrics, even if you're just doing maybe an online program where people track nutrition or steps or activity, that's collecting medical information about those employees, and the EEOC rules would apply according to our interpretation. And so, GINA here is really focused more on spouses and the collection of genetic information. Most wellness programs have stopped asking for family medical history because of GINA. You still can, as we'll see in a couple of slides here, but you have to make sure that it's voluntary and you have to communicate that very clearly. So again, big flashing red light number one for everyone to take note of. The EEOC is going to apply these to what I would consider to be almost all wellness programs. Smaller programs that maybe just the provision of a gym membership or the provision of a discount, those kind of things I don't think would apply. They would still be in the participatory wellness bucket of ACA. But almost all programs, everything we're going to look at for the rest of the day now applies, and we're no longer applying the participatory versus health contingent standard. So a very common model out there, right, is a reward for taking something as simple as a health risk assessment. And there's very few medical conditions that would prevent somebody from taking a health risk assessment, or there's an easy accommodation. And a company would provide a reward not on the outcome of that assessment, but just that you did it. That used to be defined in the participatory wellness program. The EEOC is going to define that as a wellness program that you now need to follow the 30% cap on incentives and the other requirements that we're going to discuss today. So again, can't stress this enough. The applicability of these rules has expanded significantly from just health contingent wellness programs to now all programs where employers are collecting or asking questions about an employee's health or a medical examination. So any type of surveys or biometric screen is now applicable. Reasonable design is one of the buckets that is not a significant change. ACA essentially had a reasonable design requirement, must be reasonably designed to promote health or prevent disease for all health contingent wellness programs. And the EEOC is essentially stating the same thing, that your wellness program must be kind of a reasonableness test. And I don't think this is an issue for most programs at the employer level or consultant level, so won't be spending much time here. It's essentially, this is one of those things that they list to avoid subterfuge for discrimination. Some interesting components here in terms of frequency of reward, and this goes back to kind of minimum standard. Again, the EEOC does not provide any time frame or frequency requirements in terms of wellness programming and incentives. The health contingent wellness programs, on the other hand, from the ACA, says that you must provide eligible individuals with the chance to qualify at least once per year. No one really knows. The EEOC may have said, well, since this is already clearly codified in healthcare reform, we're not going to address it. But again, here's where, although I said normally the EEOC has the tougher standards, the ACA has qualified exactly if you have a incentive program and a health contingent wellness plan, you've got to provide the opportunity to qualify once per year. And, you know, they do not reiterate that in the EEOC regulations. So here's where we kind of get into semantics. And this also comes back specifically to the EEOC's theme of voluntary. They spent a massive amount of time and ink on this subject, where HIPAA and the ACA focus on the parameters to ensure fairness regardless of health factor. The EEOC uses the term voluntary. So this is really important because this is where we see that you can no longer use wellness programs to define eligibility for health programs. Most common example in the marketplace was you have to participate in X, Y, or X wellness initiative to take advantage of Y health plan. And the EEOC is saying that that has to go away. HIPAA and the ACA focused on the reasonable alternative process to make sure that everyone was being treated fairly regardless of health factor. The EEOC is going a step farther in saying that participation in programs that include a disability-related inquiry, so think health risk assessment, biometric screening, they cannot be or must be voluntary. So employers can no longer require employees to participate. So that wasn't a significant component in the marketplace. We didn't see many employers mandating wellness participation as a term of employment. But we did see that employers denying health insurance benefits or reduction in benefits for not participating. So for example, there are employers in the space that have multiple medical plan options available. And many of these employers would say, if you participate in the wellness program, you could choose from all options. If you didn't participate in wellness, you could only take the high deductible plan. And it's our interpretation of you cannot deny health insurance or reduce health benefits for not participating, with the exception of the incentive structures that we're going to discuss in a couple of slides here. So, and finally, you can't take adverse employment action or retaliate against employees who choose not to participate or achieve certain health outcomes. And so, you know, it's interesting that we think that this is going to restrict kind of plan design options that used to rely on wellness for eligibility requirements. GINA here really focuses on the collection of family history of data. And this is largely a non-issue, as I mentioned before, as most health risk assessments and wellness programs removed those questions. I obviously included those parameters for inclusion here for your reference, but we won't spend too much time on that. So here's where the majority of our questions come in. HIPAA has no limit on participatory wellness programs. Health contingent programs cannot exceed 30% of the employee-only coverage, or up to 50% if the program is designed to prevent tobacco use. The reward is based off of the total cost of the single coverage if it's just employees, or it's the total cost of family coverage if spouses are allowed to participate. And that was clarified. VOC here really kind of complicates the issue. You know, for wellness programs that are part of a group health plan, the employers may offer limited incentives to employees to participate in those programs, but not more than 30% of the total cost of employee-only coverage. What's interesting now is that they did change how they compute the calculation for spouses. So if an employee and a spouse participate in the program, the employee is, you can only apply the 30% to both of them of the 30% of the employee-only coverage. So I butchered my words there. Let me simplify this. Essentially what they've said is that the spouse can now be incentivized to participate but it's still not to exceed 30% of the total cost of the single coverage of the health plan. And it's interesting that they complicate this really on the 50% rule involving tobacco, because now, according to the EEOC, an employer can only offer incentives as high as 50% of the total cost of coverage if the incentive is tied to a self-reporting of nicotine use or not. So this is completely backwards from what the industry would normally suggest and what works the best. Self-reported information on tobacco use has been proven to be largely inaccurate. But the EEOC, because they have an aversion to forcing people to do screens, is saying that employers can go up to 50% of the total cost of coverage if tobacco use is self-reported, but only 30% if you actually do a medical examination or an actual tobacco test. But let me give you the clarification that they provided with the final rules. So for employee only, you can only incentivize on wellness and health management programs up to 30% of the total cost of self-only coverage. So the total cost means everything an employee contributes and the employer contributes. So that's still a very good number in terms of the amount that we can incentivize employees. And this is of the amount that the employee is enrolled when the participation in the wellness program is limited to the employees on that health plan, or if the employer only offers one health plan. Where it gets a little bit more complicated is if the employer offers numerous health plans and they offer the wellness program to all of those employees in those health plans, they have to use 30% of the total cost of coverage of the lowest cost health plan available to that employee. So this is a change. Essentially, the ACA said it was 30% of the health plan that the employee was enrolled in, which, again, we think makes the most sense. But the EEOC has changed that position. They are saying that if multiple health plans are available to the employee, you have to, the incentive cap is 30% of the total cost of the lowest cost self-only coverage under the major medical group health plan that's offered. And it's interesting, if the employer offers no health plans at all, they're still using the 30% measurement, and they're applying it to the second lowest cost silver plan for a 40-year-old non-smoker on the state or federal healthcare exchange in the location that the covered entity identifies with as its principal place of business. So let me simplify this a little bit. If you only offer one health plan, the incentive cap is 30% of the total cost of self-only coverage. If you offer numerous health plans, the cap is 30% of the total cost of the lowest cost self-only coverage of any of those plans. And if you offer no health plans and you want to offer a wellness program to your employees, it's 30% of the cost of the second lowest cost of the silver plan for a 40-year-old non-smoker on the state or federal healthcare exchange. And so I think it's actually not too complicated. It's fairly consistent, but it is a change from the ACA rules that we had grown accustomed to. Essentially for the spouse, it's the exact same rule is now applied to the spouse. What's interesting was, and I saw on the previous slide that we have to make a change there, is that the previous rules was actually a complicated kind of math problem, and in the final rules here from the EEOC, they've simplified the spouse. So you can now incentivize spouses up to the 30% of the total cost of self-only coverage if there's only one group health plan. If they provide more than one group health plan, the maximum inducement is 30% of the lowest cost major medical self-only plan. And then again, you can incentivize spouses for an employer that doesn't have a health plan up to 30% of the total cost for the 40-year-old non-smoker. So essentially what's interesting is they're applying the exact same rule and calculation to employees and spouses, and there is no longer a consideration for the value of the family cost of that plan. The other interesting component in this space is that the rules for employee only are outlined in the ADA wellness final rules, and the spousal incentive caps are outlined in the question and answers of the GINA wellness final rules. I provided those links as I feel they're the best. They're the best components, or they're the best actually question and answers sheets that I've seen to answer the simple questions that your clients or employers are asking. So a lot there, and I would expect, and we'll happily answer some questions in terms of incentive caps, but they've really simplified it down to 30% of the lowest cost plan available to that employee. So uniform availability. Again, you know, ACA requires that it's available to all similarly situated individuals. ADA uses a different semantic, essentially. They say that you have to provide a reasonable accommodation, which we'll show on the next slide, and GINA doesn't address. But again, best practice would be to, in the same way that you define reasonably or similarly situated individuals under your health plan, that's who you can discriminate in terms of making different wellness programs available to you. Reasonable accommodation continues to be a semantics question. The health contingent wellness programs, you have to make the full reward available to all similarly situated individuals. And to do that, you provide a reasonable alternative standard or a waiver, depending on the employer and the plan. The ADA does not use the terms reasonable alternative standard whatsoever. They use the term must provide reasonable accommodations so that employees with disabilities can fully participate and earn any potential rewards or avoid any penalties. So it's essentially the same request, except the verbiage is different. I feel strongly that if you do a good job meeting the reasonable alternative standards for all employees under your current wellness or health management initiative, that you're going to be providing essentially reasonable accommodation to any employee with a disability. Frankly, I think the reasonable alternative standard goes past protected disabilities because healthcare reform said that you have to provide a reasonable alternative standard to anybody who didn't hit an outcome-based standard, or to anybody that has a medical need or condition in a health contingent participatory program. So I think that, again, if we follow the previous rules here, that we're going to meet the reasonable accommodation requirements. So this is a really big deal. Notice, this is another change from, I think, what we had to do before. HIPAA and ACA require that we must disclose the availability of the reasonable alternative standard to qualify for the reward, and if applicable, the possibility of waiver of the otherwise applicable standard in all plan materials describing the terms of a health contingent wellness program. So for outcome-based wellness programs, this notice must also be included in any discourse where an individual did not satisfy that outcome. So again, we had to communicate that there were reasonable accommodations in the vernacular of the EEOC or reasonable alternatives in kind of the standard speak of ACA and HIPAA. The EEOC has taken this a step farther. They have outlined that employers must provide employees with a notice that describes what medical information will be collected, who will receive it, how the information will be used, and how it will be kept confidential. That is a huge bucket, and largely we believe to be not necessary because HIPAA already and protected health information laws already mandate that all of these things must be done correctly. And most companies and their vendors like Health Check 360, when asked any of these questions, will provide the answers. And so I think this is going to add some significant administrative burdens to both employees, employers, and vendors. And I also think it's going to increase an unnecessary confidentiality discourse, because where the best outcomes in health management and wellness programs occur are when high level of integration happens, right? It's when, like at Health Check 360, when we bring claims information, biometric data, health risk assessment, utilization, and medical management into one database where those different groups are making the most appropriate interventions for an employee. So if an employee calls in with a question about the health plan to the TPA, that person knows to refer them to a health coach that's trying to talk to them about their lifestyle, or potentially a disease management nurse who's trying to advise them on the best possible way to manage their health condition. So the more integrated programs are, which yield the best results, is going to be forced to provide more additional notice and disclosure to employees. The challenge here is, and we've been getting a lot of questions specifically to this requirement, is that the EEOC has not provided their guidelines or forms on how this is going to be accomplished prior to 1/1/2017. And so one of my most common questions has been, you know, what do we have to disclose? What do we have to say? Many programs already do a very good job of disclosing that, you know, your information may be used for health coaching, medical management, or other interventions. We don't know yet what the level of detail that the EEOC is going to require and how we have to disclose this to employees. You know, how things are kept confidential become technical questions, and I just think that the need to disclose all of these things is administratively burdensome. Health Check 360 as a comprehensive vendor, we're committed to our employers and our broker consultants that we will assist all of our clients in doing this. We're just waiting on more information from the EEOC on exactly what they're looking for, because you can see, I mean, those kind of 4 main bullets. What medical information is collected, right? That's every test or potentially every health risk assessment question. Who's receiving it? That could be the wellness vendor, that could be the carrier, that could be the disease management provider, that could be, it could be the privacy officer of a self-insured health plan. How the information will be used, again, as many buckets as the program is integrated, and how it will be kept confidential, which becomes a very long and potentially complicated explanation on how data is stored and kept safe. You know, we're committed to doing this. We're committed to doing this well, but you can see that it's not a simple disclosure. We're still waiting for more information on how that's going to be disseminated to employees and what the requirements are. So, you know, what's next here? You know, according to Mercer, 88% of employers with 500 workers or more are offering some type of wellness program, you know, and 42% of those offer incentives to undergo screenings, and many of those are already on outcome-based programs. Almost all of those are doing some type of health risk assessment. And so this impacts almost every employer with a significant amount of employees in the marketplace today. So it is a change from the old rules that were codified from the ACA to the new rules. You know, prior to these final regulations, we thought there might have been a rogue office, but now we see that the Obama administration is essentially changing the position of healthcare reform through the EEOC. And I can largely say that we do not expect to see any changes to this prior to the effective date in 2017. This being an election year, although there are congressmen who are very upset, you know, John Klein from Minnesota, Lamar Alexander in Tennessee, they've introduced legislation on preserving the employee wellness programs as defined previously. I don't expect any of that to move forward until future years, and depending on the outcome of the election, it may not move forward at all. You know, I don't think that anyone should say that we're not going to follow the EEOC final rules because of the FLAMBEAU decision and other cases that they've lost. Like I said, it's interesting. You know, off the record, we've had conversations with attorneys who think that employers are very likely to win challenges because of the bona fide safe harbor. At the same time, you're only going to be able to determine that through litigation or the EEOC's challenging of that type of program design. And so, frankly, we think, again, you have to follow the least common denominator of all of these buckets, including the EEOC rules by 1/1 of 2017. Obviously, all the ACA rules, you need to be following them today. So, you know, work with your benefit consultants. Obviously, please let us know how we can help with those program designs. But stay the course. Stay aggressive with outcomes. Stay aggressive with health contingent programs, because the EEOC is giving us a lot of room. 30% of the total cost of coverage gives us a great deal of flexibility on the overall financial structures of health plans. And so, you know, determine what your strategy is from a health management point of view, and there are very specific ways and a lot of best practices on how, within the constructs of these 3 rule bases, that companies can still be extremely successful in terms of improving health and lowering costs over time. So with that, we'd love to address some questions in our last few minutes here.
Okay, great. Thanks, Michael. And we do have a number of questions here. Unsurprisingly, the majority of them are related to incentives.
Fire away.
Yeah, some of them, they might be just repeats of things that we addressed in the presentation, but never hurt to clarify things. A lot of them are clarification questions. So the first question is surrounding the surcharge for tobacco use and offering tobacco cessation. Is the applicable 30% or 50% of the total cost of employee-only coverage if they sign a affidavit and there are no other wellness incentives?
So if they're signing an affidavit. Yeah. It's my reading of this that if they're simply signing an affidavit that is not a medical screen or biometric test, that you can go up to 50% of the total cost of coverage for that smoking cessation program. Unfortunately, what we've seen in our own research and a great deal of industry research is that the affidavit process tends to be inconsistent in its fairness to employees. And the reason why is because it has no verification process, and employees can simply cheat the system by saying, I'm a non-nicotine user, because there's no biometric test to back that up. So it's still our recommendation to do a biometric test for nicotine use and go up to 30% of the cost of coverage. You know, because again, if you have a health plan where the total cost of coverage for a single plan is $6,000, 30% of the cost of coverage of that is $1,800 annually. That is more than enough to get the attention of your employees for high levels of participation and to get people to change, or, you know, we feel that's a pretty significant penalty. And so we would rather see groups use the 30% rule and test all their employees with nicotine so that you don't have one smoker that lied standing next to someone who told the truth, and the health plan is only penalizing the person that told the truth. That seems inherently unfair. We have clients that do it both ways.
I think we have a couple people asking this question. Is it possible to require a spouse to meet their health goals in order for the employee to be eligible for the incentive? So both the employee and the spouse would have to meet outcomes. It would be an all or nothing type of approach.
Obviously, that's the kind of aggressive design that we love to see. It would be my interpretation of the EEOC's position that you're treating the employee and the spouse separately, that you can go up to 30% for the employee hitting his or her goals, and you can go up to 30% of the total cost of coverage for the spouse of hitting his or her goals. I don't think that's addressed, nor do I expect to see a clarification on a design like that. I think it leaves you open to a challenge saying, I'm being treated unfairly because you're forcing my you're forcing financial penalties upon me that that only my spouse has control over. So I would probably at this point in time advise against it. I think it's complicated, and I think the best practice on communicating to employees and spouses is to hold themselves accountable.
Okay, the EEOC rules list reimbursement of part or all of fitness center membership as a participatory wellness program. Does that reimbursement need to be included in the 30% incentive threshold?
I would have to kind of specifically look that up as you did, but I would think that it would not be, because that's essentially a benefit that's not involving the collection of employee health information or employee biometric information. But we can certainly follow up on that. But I think that would be outside of the EEOC's definition of rules. Now, if there's any sort of you have to actually go to the program or go to the gym or anything like that, I think that changes, and I think all of a sudden that is an applicable program.
Okay, we have a question here around the IRS saying that employer-paid incentives are taxable income of the employee, including health club reimbursement for fitness membership. Yeah,
absolutely. IRS rule, I mean, none of these rules impact IRS rules on income. And so, most, again, best practice plan design, what we see today is most of those incentives are coming through the health plan. And the biggest advantage of that is that they're non-taxable, right? If you shift premiums, it's a non-taxable benefit that you're providing to those who are either participating or hitting their health outcome. If you don't use premiums or plan design or something within that 30%, and you're simply providing gift cards or cash or a additional pay, anything that has a cash value, the IRS is certainly going to view that as income, and it is taxable.
Okay, we have another question here about deductible incentives. Is it acceptable to have a deductible buy down if employees meet certain health standards?
Yeah, I think it is, as long as the deductible stays, the buy down stays within 30% of the total cost of the plan. A couple things for you to consider in terms of deductibles as the use of incentives. Keep in mind that on an average health plan, the vast majority of employees don't actually hit their deductibles. And if you break that further into employees, spouses, dependents, etc., I think it's something less than 30% of people actually hit their annual deductible. And so the biggest benefit that you're actually providing is to the unhealthy or the high utilizers of your health plan. Your healthiest employees and your young employees that are doing the right things health-wise or lifestyle-wise shouldn't be using the health plan hardly at all, because preventative care is already paid for and doesn't hit their deductible. So although on the surface we've seen that those type of models can drive high levels of participation because the perceived value of the plan is significant, when you say instead of a $5,000 deductible, if you participate in a wellness program or hit your goal, you're going to have a $4,000 deductible. Again, that $1,000 being within the 30% rule. Most employees don't actually get the full value of it, and so they value it less. Whereas if you shifted $1,000 worth of premium costs, your healthy people are motivated to stay healthy, your unhealthy are motivated to improve, and your highest cost participants are motivated to be compliant with care and meet their goals. And so we see deductible changes. It's not uncommon. And it's certainly not illegal, and can certainly be accommodated within the newest rules, as long as you're within the 30% line. Just give some consideration from a consulting point of view to, is this really rewarding the people that I want to reward through my wellness program? And I think it's an interesting and potentially good idea. It just warrants I think a conversation with your consultant and the employer.
Okay, we have someone looking for some clarification on the ability to charge extra premium dollars for non-participants.
Yeah, that's certainly fine. So as long as your incentive structure within the health plan meets the 30% rule, it's available to similarly situated, and everything that we discussed today, you can certainly have a penalty. Both the ACA and the EEOC, both, they do not consider a discount or a surcharge to be any different. The difference between the eligible or the incentive eligible and not eligible is what they are using for the calculation. And so if someone chooses to not participate, the EEOC's primary concern is that the penalty for non-participation is not more than, non-participation in the wellness initiative, but they're still on the health plan, is not more than 30% of the total cost of the lowest plan available to them. So when I say they're concerned about the removal of benefits, you can no longer say that because you didn't participate, this health plan is no longer available to you. Or we offer 3 health plans, and because you didn't participate or hit your outcome in the wellness program, you can only choose from 2 of the 3. That goes away. You're restricting benefits. You're not providing an incentive within the rules provided.
Okay, everyone, thanks for sticking with us. We do have a few more questions that we'll work through if you want to remain on the line and listen in to some other questions and the answers to those questions. Another question around clarifying the premium for employees and spouses. So they're saying the new rule allows for 30% of the single premium for the employee. Is that an additional separate 30% for the spouse, equaling up to a total of 60% for both?
Yes. So you can go up to 30% for the employee, and you can go up to 30% for the spouse, which actually does go up to 60% in a way. But it doesn't actually, because, so you can't combine them. The calculation is going to be separate. So it's a fixed number. So again, on the example that I provided, if the health plan total cost for the lowest cost single coverage that the company offers is a total cost value of $6,000, you can provide an incentive up to $1,800 a year for the employee and up to $1,800 a year for the spouse. If the employee doesn't use it all, you can't add it on to the spouse. If the spouse doesn't do it, you can't add it on to the employee. It's just a very simple calculation, and I think it potentially, we haven't worked through this yet, but it potentially does add some payroll buckets. But that's how I think they're calculating it.
What incentive would you recommend to encourage spouses to participate without penalizing the employee if the spouse does not participate?
Well, if the spouse is on a family plan and you can go up to $1,800 a month, I mean, I think that you have a massive potential for paying to get the spouse to participate. I don't think it necessarily, because the employee is still on a family plan. It doesn't change that, right? So if a spouse doesn't do it, the fact that you could penalize up to, multiple $1,000s a year still gives the employer a ton of flexibility on getting spouses to participate. I don't think it necessarily increases spousal participation by removing the incentive of the employee to be able to get an incentive if the spouse doesn't do it. The reality of it is if the family unit doesn't value the $1,000 that they're going to lose for the spouse not doing it, that's a choice they're willing to make, and frankly, the health plan is going to make it's going to get a lot more money back because of that decision. And so, we recommend all kinds of incentive designs, but again, there could be, like I said, a shift of $50, $100, $150 a month if a spouse doesn't participate. And to me, I know it would for me, that would be a pretty significant incentive for me to go home and say, wife or husband, I need you to participate in this initiative.
Okay, there's a question here about health savings account contributions. Is that considered to be part of a 30% limit, assuming that the contributions are tied to health-based incentives?
Yeah, I think regardless of whether they're tied to health outcomes or health-based incentives, if you are getting an additional HSA contribution that's linked to participation in the wellness program, those dollars would be counted in the 30% calculation. Very strongly believe that.
Okay, we have a couple questions here on nicotine and tobacco-free programming, affidavits, etc. Someone has an interesting question. If someone indicates they're tobacco-free on an affidavit and it is determined that they were untruthful, can they be required to pay back the incentive they have already received?
You know, according to the EEOC and kind of the rules, unclear. You know, essentially it's kind of the question of saying, hey, if someone says, I don't smoke in the affidavit process, but then they openly smoke a cigarette in front of the HR director as they're walking into work, you know, that's a good question for your attorney. And, you know, I would say that you definitely could penalize up to 30%, right? But if you're going up to 50, you know, the question is unknown, right? Because I don't think at that point in time you can say, okay, I'm going to make you take a nicotine test. And because by doing that, you would actually minimize your ability to penalize them. We've seen clients that the penalty of the affidavit process, right, if they are proven to have been smoking later, would cap benefits in other programs. That's just outside of my particular area of expertise, in that I think you've got it's more of a labor issue, and I don't think I would want to provide guidance on how to address that situation. Frankly, to prevent that situation is why we like to say, test everybody for nicotine, shift costs that way, maximize the 30%, because $1,800 is more than enough of a penalty, and you're doing it fairly and accurately because you have a blood test and you're not relying on self-reported information.
Okay, another question on nicotine incentives. If they test for nicotine and do not comply, they're given a $100 surcharge. Would that then be considered a mandatory program?
No, because the $100 surcharge would fall within the 30% rule under most health plans.
Okay, someone asking about just testing for biometrics, doing lab testing for an insurance premium discount. Do these employees need to sign any sort of affidavit?
Well, you know, at Health Check 360, we certainly typically ask people to sign a willingness to participate and how their data is going to be flowing and used. There are no new requirements in terms of an affidavit or anything like that from this. I think that what we'll find at some point prior to 1/1 of 2017 is what the wellness program and employer benefit plan is expected to communicate to employees prior to that. You know, I think it would be silly if your vendors didn't have some type of sign-off process prior to the willingness to give blood or do a finger stick or some type of biometric. I know we certainly have all of our participants, it's not an affidavit, but it's a consent form to the program. And if that's not in place, I'm happy to discuss what we do offline. If you're doing biometric screenings without any type of consent from the employee, I would probably advise you to talk to your consultant and or your vendor.
Okay, and then final question, everyone. Someone just wants to confirm what the 30% is based on for the incentive penalty criteria.
Yeah, it's the total cost of coverage. So if you're on a fully insured plan and the premium for that plan is $6,000 a year, that's the total cost of self-only coverage. You know, it is not what the employee contributes, it's what the employee and the employer total contribute to pay the premium for that single plan. For a self-insured group, it's the total contributions for that plan. So again, if the plan is $6,000, you know, or a good rule of thumb would be the COBRA cost of coverage minus 2% for like the administrative consideration. So again, it's a simple calculation, but people make this mistake all the time, especially employers. they think that the 30% is limited to what an employee pays. So if an employee pays $100 a month in premium, your cap is not 30%. Your cap is 30% of the total premium, which is the $100 plus the $500 that the employer is kicking in. So you have a lot more room for incentives than most employers and consultants that we see give themselves credit for. 30% is a pretty good number. It's going to give us a lot of space to provide as strong of an incentive structure as most groups would want to go to.
And that is 30% of the lowest cost plan provided by the employer for employee self-coverage, even regardless of enrollment in more expensive plans. That's
correct.
Okay.
And that's a change because previously it was of the plan that that specific employee was enrolled in. The EEOC is now saying it's 30% of the total cost of the lowest cost self-only coverage when more than one health plan is offered. So pretty straightforward.
Okay, perfect. It looks like we've handled most everyone's questions, but again, thank you, Michael, for taking the time to present on this topic for all of us. If anyone does have any questions that pop up in the meantime after they've kind of absorbed all of this information, feel free to contact us. We will be sending a follow-up email with links to the presentation recording and contact information. I hope you all enjoyed this information. In the meantime, keep your eyes open for an invitation to our next webinar. Have a great day.